Okay, let's unpack this. Picture this. October 22nd, 1974. A Tuesday like any other, perhaps. And on this particular day, a 60-year-old laborer named Michael Kelly, only his second day on the job for London Transport, has a minor mishap. He bumps his head.
Right.
It's a slight cut, nothing major, swiftly patched up. The kind of minor workplace incident that happens every day. Absolutely unremarkable.
On the face of it, yeah, completely routine. A small cut, maybe a few minutes with the first aid kit, and back to work. You'd log it, move on. There was zero indication, no hint whatsoever that this trivial little bump, this minor cut that happened in, the blink of an eye, would somehow detonate into a genuinely remarkable legal saga. A courtroom drama that would unfold not over weeks or months, but stretch out across years.
And here's where it gets almost unbelievable. That tiny injury somehow spiraled into a claim for a staggering £100,000. Think about what £100,000 was worth in the mid-1970s. It was a fortune. How on earth does a slight cut transform into a demand for that kind of money? That question sits at the very core of this story. It immediately signals the deep, tangled involvement of lawyers, medical experts, and, critically for our deep dive today, a set of ethical dilemmas so profound they would send shockwaves through the legal profession.
This isn't your average dry legal case study. Frame it in your mind as a legal thriller. A cautionary thriller even, like a real-life legal procedural maybe,
Yeah.
or a true crime narrative where the seemingly simple starting point unravels to reveal something far more complex and, frankly, deeply troubling about the systems involved.
Right.
It wasn't just about the money or even the injury itself. It became fundamentally about the integrity of the legal process, and perhaps most pointedly, the integrity of the expert evidence that was put before the court.
And that is precisely our mission in this deep dive.
Yeah.
We're going to meticulously unpack the case of Kelly v. London Transport Executive. Using the sources you've shared, the court reports, the legal analyses, we're going to follow the narrative arc, understand exactly how this audacious claim was constructed and how it unfolded. We'll get to know the key players, this quite colorful cast of characters whose actions shaped the outcome.
Yeah.
And most importantly, we will pull out the profound ethical lessons it holds, lessons that remain absolutely critical today, especially if you're considering or already pursuing a career at the bar. Our sources highlight how this case wasn't just another judgment, it became a touchstone, particularly in an area often whispered about as one of the dark secrets of the legal profession. The preparation of witnesses, especially expert witnesses, where the ethical lines can feel, well, frustratingly uncertain.
What's so powerful about this case is how a single set of events, originating from that insignificant bump, became so remarkably influential. It didn't just resolve a dispute, it directly influenced legal rules and practices for barristers and solicitors alike, helping to cement and shape the very definition of what independent expert evidence truly means in the context of adversarial litigation. It's a story that serves as a stark warning to aspiring lawyers, illustrating with vivid, real-world consequences precisely where that crucial ethical line is drawn and the severe repercussions for daring to cross it. It's embedded in the lore, a case young lawyers are told to remember.
So why should this specific case, one from way back in 1974, matter to you right now? Because the lessons from Kelly transcend time. This case became foundational for understanding legal ethics surrounding expert witnesses. It's a stark, compelling reminder of the duties lawyers owe not just to their client, but first and foremost to the court and to the truth. It's a story that continues to shape expectations around how expert testimony should be prepared and presented, serving as an uncomfortable but essential guidepost on the ethical tightrope that lawyers, and indeed anyone involved in litigation, walks every single day. It shows you the consequences, laid bare in a public judgment.
Now, as any good drama requires, this saga features a compelling and, as our sources describe them, colorful cast of characters. Their individual actions, their decisions, their expert opinions, or the way those opinions were handled, collectively propelled this relatively minor incident to a major legal battleground and, subsequently, a landmark ethical discussion. Let's introduce the dramatis personae.
At the absolute center of this storm, of course, is Michael Kelly, the plaintiff. You could see him as the protagonist who, perhaps through circumstance or design, morphed into something more akin to an antagonist in the narrative told by the courts. He was an Irish-born laborer, age 60, according to the outline description at the start of our story. The one source notes he was 53 when he began work at London Transport. Lord Denning, the incredibly famous judge we'll meet later, described him with language that tells you a lot about how he was perceived. A plausible Irishman and a chronic alcoholic.
Wow, quite a description.
Right. Kelly had a background marked by intermittent work and heavy drinking. His core claim, the one that stretched credibility so thin, was that this single minor head bump back in 1974 was the sole cause, the direct trigger for what he claimed were severe, life-altering problems. Deep depression, significant hearing loss, persistent eye trouble.
And pinning all of that on one small bump.
Exactly. His credibility and the plausibility of this causal link became the central contested issue throughout the entire duration of the case.
Then we enter the complex world of the experts, whose involvement was crucial to both the case itself and the subsequent ethical firestorm. Representing Michael Kelly's side, we first encountered Dr. M. Denham, a psychiatric expert. Our sources describe him as an experienced specialist who unfortunately found himself becoming, in their words, an unwitting supporting actor in the ethical controversy.
Unwitting.
He initially produced a psychiatric report in late 1979, but, and this is absolutely critical to the story, he issued a revised report in March 1980. This revised report, issued after consultation with Kelly's legal team, dramatically strengthened the asserted link between Kelly's diagnosed depression and that relatively minor accident.
So a change in the report.
A significant change. This change in stance, seemingly influenced by the lawyers, led the trial judge, Mr. Justice Caulfield, to deliver a damning assessment, describing Dr. Denham as over-obliging.
Over-obliging. That's quite something for a judge to say about an expert.
Absolutely. This conduct by the expert, seemingly bending his opinion to suit the case, ignited the central debate around the propriety of coaching expert witnesses.
Standing in stark contrast to Dr. Denham was Dr. Dennis Lee, the psychiatric expert enlisted by London Transport, the defendant. He represents, in this legal drama, what you could call the voice of reality, grounded in clinical assessment rather than aligning with the plaintiff's narrative.
Okay, the defense expert.
Right. Dr. Lee was one of 5 specialists enlisted by the defense to rigorously examine Kelly and his claims. He produced a damning June 1980 report, concluding with absolute clarity that the head bump had no relationship whatsoever to Kelly's psychological condition or other alleged issues.
No relationship at all.
None. His diagnosis was blunt and medically supported. Kelly was a chronic alcoholic, showing signs of early dementia and suffering from a delusional state characteristic of chronic alcoholism, citing clear episodes of delirium tremens.
Oof. That's a completely different picture.
Completely. His detailed, unvarnished report stands as a powerful example of what defense experts were finding, and starkly highlights the difference between unbiased expert testimony and evidence that appears, well, tinged by advocacy.
The lengths the plaintiff's side went to are further illustrated by the inclusion of Colonel R. Hands, a machinery expert brought in for Kelly's case. He was a retired military engineer, involved in exploring what the sources call an obscure aspect of the claim, seemingly related to the mechanism of the injury itself.
A machinery expert. For a bump on the head.
Seems a bit tangential, doesn't it? His role was ultimately fleeting, almost peripheral. The trial judge, Mr. Justice Caulfield, dismissed his testimony entirely as of no consequence, stating he merely attempted to prove the obvious.
Right.
But his presence serves as a telling detail, showing how far Kelly's team went, bringing in experts from seemingly unrelated fields in an effort to find any angle that might lend credibility to the elaborate, overarching claim they were trying to build around that minor head bump.
Moving to the legal teams who navigated this complex landscape. Representing London Transport, the defendant, as lead counsel, was Mr. Anthony Scrivener, QC. He was described as a formidable English barrister, a Queen's Counsel of rising renown, even at this relatively early stage in his prominent career.
A big name, then.
Definitely. His task was immense, to meticulously unravel Kelly's increasingly elaborate and questionable claims. Scrivener embodies the skeptical eye of the establishment in this story, determined to expose what appeared to be a baseless exaggeration. His strategy was multi-pronged, deploying top-notch expert evidence, like Dr. Lee's, to scientifically debunk the plaintiff's narrative, and crucially, actively pressing the issue of how Kelly's case was being constructed and potentially manipulated behind the scenes by his own legal team.
Going after the process itself. Assisting Mr. Scrivener, QC, on the defense side was Mr. Christopher Carling, the junior counsel for London Transport. In the traditional barrister hierarchy, the junior counsel plays a vital supporting role, often handling the painstaking work of mastering dense evidential material like the voluminous medical reports in this case.
Yeah, all those reports.
Exactly. And potentially conducting parts of the cross-examination of witnesses or experts. Together, Scrivener and Carling formed the consistent barrister team, working to methodically dismantle the plaintiff's increasingly shaky case.
The legal landscape for Kelly's side shifts somewhat, particularly at the appeal stage. When London Transport challenged the outcome on costs, it wasn't Kelly himself appearing, but effectively the legal aid fund defending the position they had funded. Their counsel on appeal was Mr. Duncan Matheson.
Okay, so representing the fund.
Yes. He entered the picture at the appellate stage, effectively representing the interests of the Law Society and the Legal Aid Fund. His role involved trying to justify the conduct of Kelly's legal team, particularly concerning the expert evidence preparation. And, as we'll discuss, he made a significant, candid admission during the appeal that shed crucial light on who was advising the changes to Dr. Denham's report.
Ah, intriguing. Mr. Matheson was supported by Mr. Nigel Pitt, his junior counsel for the Law Society on the appeal. The presence of both a senior and junior barrister representing the legal aid fund at this appeal stage underscores the seriousness with which the legal aid authorities viewed London Transport's unusual and significant challenge regarding the irrecoverable costs of the case.
Guiding London Transport's legal strategy in handling the ground-level work was Mr. V.J. Morefoot, their instructing solicitor. The solicitor is the behind-the-scenes detective and coordinator in litigation. Mr. Morefoot's role was crucial. Coordinating the defense investigation, securing and instructing their panel of 5 experts, obtaining crucial background information on Kelly, and handling all the procedural heavy lifting required to build a robust defense against a complex claim.
The engine room, essentially.
Precisely. He was the steady hand managing the defense side.
On Michael Kelly's side, the instructing solicitor of record, or more accurately, the official within the legal aid system overseeing and authorizing funding for the case, was Mr. P.E. Putt, the area legal aid secretary. Mr. Putt essentially represented the state-assisted machinery that enabled Kelly's claim to be pursued, funding the extensive array of experts and legal teams.
So he held the purse strings.
In effect, yes. He was responsible for approving the funding for all aspects of Kelly's case and was ultimately called upon to account for the decisions made under his authority, particularly regarding the expenditure of public funds on this claim.
Presiding over the initial trial, the man who had to weigh all this conflicting evidence and deliver judgment was Mr. Justice John Caulfield. Our sources note he was known for his picturesque language, a trait that certainly came to the fore in his judgment.
Oh, I like a judge with colorful language.
Me too. He delivered the dramatic denouement, the moment where the carefully constructed plaintiff's case collapsed under scrutiny. Judge Caulfield didn't just dismiss Kelly's core story. He delivered pointed criticism, specifically castigating the expert who bent to the plaintiff's will.
Castigating. Strong word.
Very. His vivid phrasing, like describing Dr. Denham as over-obliging in his quest for the plaintiff, starkly highlighted the judge's view of what had transpired with the expert evidence and set the stage for the higher court's review.
The case reached its most ethically significant point in the Court of Appeal, presided over by Lord Alfred Tom Denning, the Master of the Rolls, arguably one of the most renowned and certainly one of the most colorful English judges of the 20th century.
A true legend of the law.
Absolutely. Lord Denning, despite being towards the end of his long career, seized upon this case. He used it as a platform to pontificate on legal ethics and the duties of lawyers with characteristic energy and conviction. His judicial style was characteristically narrative-driven and forceful, often prioritizing what he saw as justice according to common sense.
Right.
In his judgment on the Kelly case, he would issue a thundering condemnation against the doctoring of expert evidence, providing the sharp, quotable lines and strong moral conclusions that cemented this case's place in ethical discussions.
Sitting alongside Lord Denning on the Court of Appeal panel were Lord Justice Sir Donald Ackner and Lord Justice William O'Connor. Lord Justice Ackner, a brilliant jurist in his own right, played what's described as a quieter supporting role in the judgment, providing robust legal reasoning that underpinned and validated Lord Denning's more powerful ethical pronouncements.
Providing the legal heft.
Exactly. Lord Justice O'Connor was the third judge on the panel. He concurred with his brethren, affirming the unanimous stance of the appellate court against the ethical issues raised by the case.
Finally, though not a direct participant in the Kelly case itself, the shadow looms large of Lord Wilberforce from the House of Lords. His pronouncements in an earlier separate case called Whitehouse v. Jordan were absolutely pivotal to the ethical analysis in Kelly.
The Whitehouse case. Crucial precedent.
Hugely. His famous dictum, stating that expert evidence presented to the court should be the independent product of the expert, uninfluenced by the pressures of litigation, was the guiding star for Lord Denning's ethical critique in Kelly. Lord Wilberforce represents that voice of high principle from the ultimate court, providing the fundamental rule that Denning so forcefully applied.
Wow, quite the ensemble cast. From the injured laborer at the center to an array of experts with contrasting opinions, dedicated solicitors managing the process, sharp barristers arguing the points, a memorable trial judge, and legal titans like Lord Denning weighing in on appeal. It's a reminder that even cases starting from a simple bump can involve a complex web of individuals, each playing their part in the unfolding drama.
Absolutely. And now let's trace the actual timeline, the procedural journey of this saga. How did we get from a seemingly minor injury in 1974 to a landmark ethical ruling in 1982? We'll walk through the litigation steps, noting who was involved at each stage where our sources provide that detail.
It begins, as we know, on October 22nd, 1974. Michael Kelly, then aged 53, is on his second day working for London Transport. He sustains a slight cut to his head, it was treated quickly, and he returned to work the same day. At this point, no lawyers, no experts, just a minor workplace injury report, if that.
Just internal procedures, presumably. London Transport would have been represented internally, or perhaps by their standard legal advisors for such small matters.
The first significant shift occurs in March 1975, just 5 months later. Kelly quits his job. Our sources indicate that around this time, he begins living on Social Security and was heavily engaged in drinking.
Okay, so his circumstances change quite a bit.
They do. Then, in July 1975, the complaints start to crystallize. This is when Kelly begins to formally attribute a wide array of problems, depression, anxiety, blurred vision, hearing loss, to that single, seemingly trivial head bump from the previous year.
Right, so now he's actively linking them. He's articulating a significant long-term consequence from a minor event. London Transport, likely represented by their solicitors department, would have received notice of this claim developing.
Fast forward 2 more years to 1977. Kelly's complaints and his assertion of a link to the accident gained traction, leading him to engage a firm of solicitors. Our sources don't name this initial firm explicitly, but they took his statement and, presumably assessing its potential, sent him to 2 barristers for an initial opinion on the strength of the case.
Getting counsel's view early on.
Exactly. These barristers, again unnamed in the sources, provided a positive opinion. This positive view was significant enough to justify exploring the possibility of publicly funded legal representation.
Which leads to legal aid. This led to the application for legal aid. In April 1977, legal aid was indeed granted, but initially it was cautious and limited. The grant was strictly restricted to funding a more in-depth counsel's opinion.
So just dipping a toe in the water?
Pretty much. The Legal Aid Board, managed by officials like Mr. P.E. Putt, the area legal aid secretary overseeing this case, wanted a clearer, more robust assessment from experienced counsel before committing substantial public funds to a full-blown lawsuit involving potentially complex medical claims. London Transport solicitor Mr. V.J. Morefoot would have been aware of the application and the limited grant.
That more in-depth counsel's opinion turned out to be quite substantial in an 18-page report delivered in January 1980. Our sources highlight this report as playing a key role later. But already by July 1977, just a few months after the initial limited grant, the legal aid certificate was expanded.
Okay, so they got the green light to proceed.
Yes. Buoyed by favorable advice, presumably from that initial counsel's opinion, the certificate was widened to allow the case to proceed through the formal lawsuit stage, the pleadings. So, by mid-1977, Michael Kelly's claim was officially launched in court, backed by state funding overseen by Mr. P.E. Putt's office. London Transport, through Mr. Morefoot, would have received the formal court documents initiating the action.
What ensued from 1977, once a lawsuit was formally filed, right up to October 1980, was an extraordinary pre-trial phase, dominated by what our sources aptly term an expert avalanche.
An avalanche, I like that.
It really fits. Michael Kelly's side, funded by the expanded legal aid, began engaging a multitude of experts across various fields to substantiate his wide-ranging complaints. Eye specialists for his vision, an ear specialist for his hearing, several psychiatrists for his mental health, and even the machinery expert, Colonel Hands, to examine the accident mechanism.
Covering all bases, it seems.
Or trying to. The sheer volume of expert material generated was immense. The trial judge, Mr. Justice Caulfield, later expressed astonishment from the bench, stating, "There are more documents on the medical issue in this case than I have ever seen in the whole of my career at the bar and on the bench."
Wow. Let's zero in on the development of these crucial expert reports from Kelly's side, as this is where the ethical issues truly began to manifest. For the eye complaint, 2 specialists were involved, producing 4 reports in total. However, investigations uncovered a critical piece of information. Kelly had suffered an injury in a drunken brawl back in 1971.
Ah, a prior injury.
Yes, 3 years before the head bump in 1974. This prior injury directly contradicted the claim that the 1974 bump caused his eye problems. By June 1980, one of the eye experts, confronted with this information, effectively abandoned their supportive opinion. In their words, they admitted to being led up the garden path.
Oh, dear.
In linking the eye issues to the 1974 accident, conceding the 1971 incident was the likely cause. This specific concession weakened a major limb of Kelly's claim, exposing how his history was complicating the narrative.
Okay, so the eye claim starts to crumble. The hearing loss claim followed a similar trajectory. One specialist conducted no less than 8 separate exams and tests on Kelly.
8 exams.
8. Yet, despite all this investigation, by June 1980, the conclusion was clear. There was no measurable hearing loss that could be attributed to the 1974 accident. Any hearing issues were deemed mainly psychological.
So another part of the claim debunked by his own expert.
Essentially, yes. So another major component of Kelly's claim effectively evaporated under expert scrutiny, leaving the case increasingly reliant on the psychiatric evidence.
Right. Which brings us back to Dr. Denham. The psychiatric claims became the central battleground and the source of the most significant ethical controversy. Kelly's team initially consulted 3 psychiatrists, generating 7 reports between them. However, 2 of these experts were ultimately dropped by Kelly's legal team.
Dropped? Why?
Presumably because their opinions didn't sufficiently support the strong causal link, Kelly was asserting. This left Dr. M. Denham as the primary psychiatric expert. His initial report, provided in December 1979, was seemingly more guarded or nuanced about the cause of Kelly's depression. But then came the crucial moment. Following consultation with Kelly's legal team specifically, with Kelly's solicitors, Mr. Putt's office, acting on counsel's advice.
Ah, counsel's advice. Important detail.
Very. A revised report was produced by Dr. Denham in March 1980. This new report dramatically strengthened the causal assertion, now positively stating that Kelly's depression was caused by and consequent to the head accident.
Wow, that's a major shift in opinion. This revised report and the process behind its creation would later be revealed as the smoking gun of the case, starkly illustrating the alleged manipulation of expert opinion.
As mentioned earlier, Colonel R. Hands, the machinery expert, was also engaged, obtaining leave from the court to be involved. However, as the judge later found, his testimony proved of no consequence, simply attempting to prove a self-evident point.
Yeah, proving the obvious. His inclusion, however, shows the exhaustive and perhaps desperate efforts made by Kelly's legal team, overseen by Mr. Putt's office and guided by counsel, to build supporting evidence for every conceivable angle of the claim, no matter how tenuous.
Throughout this pretrial period, London Transport's legal team, comprising solicitor Mr. V.J. Morefoot and barristers Mr. Anthony Scrivener, QC, and Mr. Christopher Carling, were actively building their defense. They didn't just passively receive Kelly's expert reports, they proactively assembled their own formidable panel of 5 specialists.
They're shadow experts.
Exactly. These experts served as shadow experts, attending Kelly's examinations conducted by the plaintiff's experts and consulting closely with the defense legal team, Morefoot, Scrivener, and Carling, to prepare a robust, evidence-based rebuttal to every claim Kelly was making.
The defense expert evidence was powerful and consistent. Dr. Dennis Lee's psychiatric report in June 1980 was particularly devastating to Kelly's case, providing the clear medical opinion that alcoholism and dementia, not the head bump, were the cause of Kelly's problem.
Right, the voice of reality.
Precisely. This report, along with the findings of LTE's other experts, gave London Transport's legal team, Morefoot, Scrivener, Carling, the necessary ammunition to completely dismantle Kelly's causal claims based on solid medical evidence.
A telling detail in the lead-up to trial concerns the exchange of information. In February 1980, Mr. Morefoot, London Transport solicitor, shared their defense medical reports, including Dr. Lee's damning report, with Kelly's solicitors, Mr. Putt's office, as they became available.
Okay, so the defense put their cards on the table early.
It seems so. This early disclosure by the defense could be seen as either a gesture of fairness or perhaps a strategic move to put pressure on Kelly's team by revealing the strength of their counter-evidence.
However, What's highly significant is that Kelly's side did not fully reciprocate this open exchange. They only disclosed the revised Dr. Denham report, the one that dramatically strengthened the link to the accident.
Ah, holding things back.
Exactly. They held back other less favorable reports, including the earlier version of Dr. Denham's opinion and the increasingly negative findings from the eye and ear experts until the very late stage. This selective disclosure became a major point of contention, only revealing the full picture to the defense just 2 weeks before the trial was set to begin.
By mid-1980, despite the mounting evidence from both sides suggesting weaknesses in Kelly's claim, his legal team decided to push forward towards trial. The 18-page counsel's opinion from January 1980 had apparently advised pressing on.
Even with the emerging problem.
Apparently so. This led to a crucial development regarding legal representation. Kelly's team sought and was granted under an unlimited legal aid certificate issued in February 1980 permission to retain leading counsel, a Queen's counsel for the trial itself.
Upping the stakes of the QC.
Yes. So by this stage, Kelly's representation under legal aid, overseen by Mr. P.E. Putt, had expanded to include senior counsel in addition to the original team, while London Transport was consistently represented by Mr. Morfoot, Mr. Scrivener QC, and Mr. Carling throughout this preparatory period.
Amidst this escalating legal battle, a significant opportunity for resolution arose in mid-1980. London Transport, recognizing the increasing fragility of Kelly's claims, but also facing mounting legal costs, made a settlement offer of £4,000.
£4,000 compared to the £100,000 claim.
Quite a difference. This figure included £750 that London Transport had already paid into court earlier as a procedural step. Our sources describe this offer as generous, considering the reality being revealed by the expert reports.
But they didn't take it.
No. However, Michael Kelly was described as unable to conduct his affairs, meaning the decision on settlement rested entirely with his lawyers. Based on an informal counsel's opinion, the offer was rejected.
Wow. A missed chance, maybe.
In hindsight, absolutely. This decision committed the case to a full trial, despite the writing being increasingly on the wall regarding the claim's validity.
The final weeks before the trial saw the full disclosure that should have happened much earlier. On October 13, 1980, just 2 weeks before the trial date, Kelly's solicitors finally turned over the remaining medical reports to London Transport's team.
The ones they'd been holding back.
Precisely. These reports explicitly confirmed the clear weakness of the eye and ear claims. Yet, astonishingly, despite this 11th-hour revelation of their own experts' negative findings, Kelly's lawyers decided to press on with all the original allegations.
Even though their own reports undermined them. That's bold.
Or something else. They even listed the eye and ear experts to testify at trial, although in the end they only called one eye expert, effectively dropping the other's evidence after revealing how unsupportive it was. London Transport's team, led by Mr. Morfoot and Mr. Scrivener QC, now had full sight of the weaknesses but still faced a trial on all fronts.
And so, the case proceeded to trial. It commenced in late October 1980, taking place over 3 days at the Royal Court of Justice in London, before Mr. Justice John Caulfield. The stage was set for a dramatic courtroom confrontation, with Mr. Scrivener QC ready to cross-examine on behalf of London Transport and Kelly's legal team, funded by legal aid under Mr. Putt's oversight, attempting to salvage their increasingly untenable case.
The trial proved to be the undoing of Michael Kelly's claim. Michael Kelly himself took the stand to give evidence. However, under what must have been sharp cross-examination by Mr. Scrivener QC, the judge found him to be a wholly unacceptable witness.
Not credible at all.
No. His testimony simply wasn't credible, undermining the very foundation of his narrative.
The critical moment, however, came with the testimony of Dr. M. Denham, the plaintiff's psychiatric expert. His evidence was not only challenged, but ultimately rejected completely by Judge Caulfield.
Completely rejected.
Yes. The judge went further, delivering a blistering condemnation of Dr. Denham's conduct regarding the revised report. Judge Caulfield's words, as quoted in the sources, were direct and damning. "I do not think the solicitor should have asked him anyway to have changed his report, and secondly, if the consultant was asked, he should not have obliged, and therefore he falls down in my estimation."
Wow, pointing the finger.
Absolutely.
Yeah.
This was the judge pointing directly to the coaching and manipulation of the expert evidence by Kelly's legal team, the solicitor acting on counsel's advice, and the expert's failure to maintain independence. Colonel Hans also testified, but his evidence was, as predicted, dismissed as of no consequence.
So the plaintiff's case just collapsed.
Pretty much. With Kelly's testimony discredited and his key expert evidence crumbling under scrutiny and judicial criticism, the defense case, armed with the robust reports from their own experts like Dr. Lee, needed very little direct presentation to expose the falsehoods.
On October 30th, 1980, Mr. Justice Caulfield delivered his judgment. He decisively exposed the bogus claim, finding that nearly all of Kelly's allegations about long-term injury were baseless and unconnected to the 1974 accident. He awarded a token sum of just 75 pounds to Kelly.
75 pounds after all that.
75 pounds. Acknowledging that a head bump did happen and there was a minor injury, but making it clear that the extensive, multifaceted claim for 100,000 pounds was overwhelmingly without merit. 75 pounds was, in context, a judicial dismissal wrapped up in a nominal award for the initial cut. London Transport, represented by Mr. Morfret, Mr. Scrivener QC, and Mr. Carling, had successfully defended the substance of the claim.
Then came the inevitable issue of costs. London Transport had incurred significant legal expenses defending the claim, estimated at over 8,000 pounds. Normally, the losing party pays the winner's costs. But Kelly was legally aided.
Ah, the legal aid factor again?
Right, meaning he had no personal liability for London Transport's costs. This left London Transport, the successful defendant, facing the prospect of winning the case but being significantly out of pocket due to the costs of defending a claim the judge had essentially found to be bogus.
That seems fundamentally unfair.
It certainly felt that way to London Transport. It's unclear from our sources if Judge Caulfield made a specific order against the legal aid fund for London Transport's costs at trial. But the reality was that London Transport incurred substantial irrecoverable costs.
This perceived injustice, the successful defendant being left to bear its own considerable costs after defeating a legally aided claim found to be fundamentally flawed, led to the post-trial stage and the appeal. In March 1982, London Transport took the unusual step of appealing, not against the $75 verdict, which they had accepted, but specifically against the inability to recover their defense costs.
Appealing on costs alone.
Yes. Their request was extraordinary, that their costs should be paid out of the legal aid fund itself. This was a significant challenge to the legal aid system.
The appeal was heard by a formidable panel in the Court of Appeal, Lord Denning MRR, Lord Justice Ackner, and Lord Justice O'Connor. London Transport's case was argued by Mr. Anthony Scrivener QC, reprising his role from the trial. The Law Society, tasked with defending the legal aid fund's position and justifying the handling of Kelly's case, was represented by Mr. Duncan Matheson and Mr. Nigel Pitt.
It was during the arguments before the Court of Appeal that Mr. Duncan Matheson, counsel for the Law Society, made a strikingly candid and crucial admission. When pressed on the manipulation of Dr. Denham's report, he admitted that it was not really the solicitor who was responsible for advising the changes.
Who was it then?
But rather that counsel had advised the obliteration of references to previous medical reports.
Counsel, so the barrister advised hiding things. Wow. That admission was explosive, shifting the ethical focus directly onto the barrister advising on the case, confirming that the interference with the expert's independent opinion was advised at a high level within Kelly's legal team, overseen by Mr. Putt's office as the instructing solicitors.
Lord Denning, hearing this admission and reviewing the facts, seized upon the case as a vehicle for delivering a powerful message on legal ethics. In the Court of Appeal's judgment in March 1982, he didn't mince words. He framed the entire saga as a morality tale for the legal profession.
Classic Denning.
Absolutely. He condemned the practice of lawyers interfering with expert evidence, stating unequivocally that solicitors, and by clear implication from Matheson's admission, barristers too, must not ask a medical expert to change his report, so as to favor their client or to conceal things that may be against him.
Setting down the law very clearly.
He famously quoted the principle from the House of Lords in Whitehouse v. Jordan, delivered by Lord Wilberforce. Expert evidence presented to the court should be, and should be seen to be, the independent product of the expert, uninfluenced as to form or content by the exigencies of litigation.
The independence principle.
Exactly. Denning then linked Kelly directly to Whitehouse, stating lawyers must not settle the evidence of medical experts as they did in Whitehouse v. Jordan. This reinforced the strict UK stance against lawyers shaping experts' reports, particularly where it involved omitting unhelpful information.
Despite their strong ethical condemnation and clear sympathy for London Transport's plight, the Court of Appeal ultimately found that the existing law regarding the recovery of costs against the legal aid fund was too restrictive. While they highlighted the injustice, they were legally constrained from simply ordering the fund to pay London Transport's full costs.
So London Transport still didn't get their costs back?
No. The source confirms London Transport was unable to recover costs from legal aid, winning the battle but effectively losing financially on the costs war.
However, the Kelly case, particularly Lord Denning's forceful judgment, had a lasting impact that transcended the specific outcome on costs. It became a pivotal authority. Denning's critique fueled policy discussions about the legal aid system and the need for courts to have more power to order costs against the fund in cases of abuse or misconduct.
Ah, so it led to reform.
It contributed significantly to later reforms in legal aid cost rules, making it easier for successful defendants to recover costs from the fund in certain circumstances, as noted in a 1986 Hansard debate. The procedural saga concluded, but the ethical legacy was cemented.
So let's delve into that legacy. What are the profound ethical takeaways, the cautionary lore that Kelly v. London Transport Executive imprinted on the legal profession, particularly for barristers and solicitors dealing with expert evidence? The case's significance lies far beyond the 75-5 verdict. It became, as our sources emphasize, a vivid illustration of what not to do when handling expert witnesses.
Absolutely. Kelly strongly reinforced what's known in the UK as the Whitehouse line of authority. This principle, articulated by Lord Wilberforce in Whitehouse v. Jordan and vehemently championed by Lord Denning and Kelly, firmly discourages close lawyer involvement in drafting expert reports.
Discourages putting it mildly with Denning.
True. Denning's stance in Kelly was almost absolute, showing near zero tolerance for lawyers settling experts' evidence. The fundamental principle, hammered home repeatedly, is that the expert must function as an objective informer for the court, assisting the judge or jury on technical matters, not as a soldier for one side, recruited and shaped to advocate a position.
Right, their duty is to the court first.
Precisely. Their evidence must truly be the independent product of their expertise, uninfluenced by the strategic needs of the litigation.
Now, here's where things get really interesting and reveal a divergence in approach between common law jurisdictions. While the UK doubled down on this strict Whitehouse line after Kelly, the approach that developed in Australia, often termed the federal line, stemming from cases in the federal court, takes a slightly more nuanced view.
Okay, how so?
Australian courts accept that some consultation is not only acceptable but often necessary. They acknowledge that lawyers need to interact with experts to brief them on the specific legal questions at issue, identify the relevant facts they need to consider, and even help them present their opinions in a way that is admissible and understandable to the court.
So, a bit more pragmatic, perhaps. Justice Callanan in the High Court of Australia, in the case of Boland v. Yates Property Corp., directly addressed Lord Denning's strong comments in Kelly. Callanan J. suggested that Denning's view in Kelly goes too far if interpreted as prohibiting any lawyer interaction with an expert report.
Okay, pushing back slightly on Denning.
Yes. The Australian position, while absolutely maintaining the expert's duty of independence to the court, allows lawyers to assist with the form of the report to ensure it complies with court rules, as seen in cases like Harrington Smith. They can help the expert focus on the relevant legal issues and clarify the expression of their opinions, suggesting a different form of expression. More accurately, state propositions, provided always that no attempt is made to invite the expert to distort or misstate facts or give other than honest opinions.
So, help with clarity and structure, but not content or opinion. The key is the substance must remain the expert's independent, truthful opinion.
Exactly. The line is between form and substance.
Despite this difference in the permissible degree of interaction regarding the formulation of the report, Kelly remains a powerful, universally applicable illustration of the absolute improper boundary, the bright red line that must never be crossed. The sources highlight specific ethical breaches evident in the Kelly case that would be considered professional misconduct in any jurisdiction today.
Like the coaching.
The most egregious was the coaching and manufacturing of evidence. Advising Dr. Denham to specifically omit references to previous medical reports or less supportive findings wasn't just suggesting changes to phrasing, it was an instruction to conceal unfavorable information to make the report fit the case narrative better.
That's blatantly wrong.
Absolutely. This is presented as a clear example of unethical coaching, attempting to manufacture a more favorable opinion. Under modern professional conduct rules, this would constitute serious professional misconduct, risking disciplinary action, including suspension or disbarment, for the lawyers involved.
A career-ending mistake.
Potentially, yes. There's a fundamental distinction, reinforced by Kelly, between legitimate preparation, helping the expert understand the legal process, the issues, and the questions they need to address, and illegitimate coaching, telling them what to say, or omit to present a misleading picture that serves the client's case, regardless of the expert's true, unvarnished opinion. Kelly falls firmly into the category of illegitimate coaching.
Another critical ethical lapse exposed by Kelly was the breach of the duty to disclose relevant information. Kelly's legal team withheld the earlier, less favorable version of Dr. Denham's report and other reports that undermined their claim, only producing them at the very last minute before trial.
The late disclosure ambush.
Right. This selective disclosure, hiding evidence that didn't support their case, is an attempt to mislead not only the opposing party, but ultimately the court itself. Modern civil procedure rules across jurisdictions, which mandate the mutual exchange of all expert reports, including earlier or draft versions in many instances, are designed precisely to prevent this kind of behavior, ensuring transparency and fairness.
Makes sense. Withholding such crucial evidence, as happened in Kelly, would today be a clear ethical breach.
This is also where modern expert witness codes of conduct become so vital. These codes, which are now integrated into the court rules in many places, impose specific duties directly on the expert. They typically require experts to explicitly declare their independence and acknowledge that their paramount duty is to the court, not the instructing party.
Putting the duty in writing.
Exactly. They must list all the materials they relied upon and disclose any relevant matters that might impact their opinion's validity or their independence. If Dr. Denham had been bound by such a code in 1980, he would have had a clear ethical obligation and the formal framework to resist the lawyer's request to alter his report by omitting information.
It empowers the expert.
Precisely. He would also likely have been obliged to disclose the existence of his earlier conflicting opinion and the reasons for any changes, ensuring full transparency for the court. The code empowers the expert to push back against undue pressure from lawyers.
Our sources make it clear that Kelly has become ingrained in legal education and professional training. It's cautionary lore told to young lawyers. The case, alongside Whitehouse v. Jordan, provides vivid, real-world examples of exactly what not to do.
The don't do this cases.
Pretty much. The image of blacking out lines in a report, as specifically occurred in Whitehouse, where passages indicating no negligence were removed by lawyers, serves as a powerful visual metaphor for improperly interfering with expert evidence. These cases draw a bright, undeniable line.
And the consequences.
If you cross that line, if you are found to have coached an expert to conceal unhelpful truths or attempted to mislead the court through selective disclosure, the consequences, illustrated by Kelly, are severe and public. You don't just risk losing your client's case, you risk judicial censure, being chastised in a published judgment for all to read, damaging your professional reputation potentially irrevocably, and facing disciplinary proceedings for professional misconduct.
So while there might be a slight difference in emphasis between the UK and Australian approaches on the degree to which lawyers can assist with the expression of an expert's opinion, they are in absolute agreement on the fundamental, non-negotiable core principle. The expert's opinion must remain their own and truthful.
The substance must be untouched.
Correct. The difference lies in the tolerance for shaping the form versus the substance. But even in Australia, where more interaction is permissible, the warning from Kelly resonates powerfully. Lawyers must be acutely mindful that if they stray into influencing substance, they'll be on a Whitehouse Kelly minefield.
Ultimately, Kelly stands as a powerful and uncomfortable reminder that the lawyer's paramount duty to the court and the truth always overrides their duty to the client. While you are a zealous advocate for your client, you are first and foremost an officer of the court, bound by a higher duty to the administration of justice based on truth.
That duty to the court is paramount.
And the kind of manipulation and concealment seen in Kelly, the attempts to tailor expert evidence and hide inconvenient facts for strategic gain, was a direct, blatant violation of that paramount duty. The case remains a stark, public, real-world example of the negative consequences, not just for the expert whose credibility is shattered, but for the lawyers involved, and for the integrity of the legal process itself when that crucial duty is forgotten, ignored, or deliberately undermined. It's why the case continues to be discussed and taught decades later.
Bringing this back to you, the listener, consider the journey we've taken. Kelly v. London Transport Executive, this case that began with nothing more than a minor bump on the head in 1974, unexpectedly developed into a foundational chapter in the story of legal ethics.
It wasn't merely a personal injury claim, it morphed into what our sources describe as a professional thriller, where the truly significant and lasting twist wasn't about the negligible amount of money awarded, but about the exposure and condemnation of behind-the-scenes conduct within the legal team handling the case.
The enduring message, particularly for anyone involved in the justice system, remains crystal clear and unwavering. Integrity must trump expedience. The case serves as a powerful historical warning. If you attempt to improperly settle an expert's evidence, if you advise concealing inconvenient facts, if you prioritize winning over truth, you don't merely risk losing your case.
You risk much more.
You compromise the integrity of justice itself.
The story of Kelly demonstrates that courts, even decades later, stand ready and willing to meticulously examine conduct and publicly call out such behavior, ensuring that truth, independence, and transparency remain the fundamental guiding principles of litigation. It provides the real-world consequences of ethical breaches, etched into the public record.
It leaves us with a thought to consider, one that lawyers grapple with daily. For anyone involved in preparing a witness to give evidence, whether they're a layperson recalling facts or a highly qualified expert offering opinion, how much interaction is truly necessary and legitimate for helpful preparation before it risks subtly or overtly crossing that line into suggestion, coaching, or influencing what is said or omitted?
That's the tightrope, isn't it? And for legal teams operating under the intense pressure to succeed for their clients, how can they ensure that an expert's opinion, presented in their report, isn't just stated as independent, but is genuinely formed and owned by the expert alone, free from any adversarial bias, whether that bias is a conscious effort to mislead or a more subtle, perhaps unconscious shaping influence by the client's narrative?
It's a crucial question. This dynamic, this constant ethical tightrope between zealous advocacy and the paramount duty to the court, remains one of the most vital and challenging aspects of legal practice today. Thank you for joining us for this deep dive into a case whose cautionary tale continues to shape the ethical landscape of the law.